section 2A. What is an offer? If I'm offering my hose to Sophia, yes, Sophia has accepted it. So what is an offer? Offer is nothing, just you are just giving an what you call a willingness to do or abstain from doing with a view to obtain the assent of the other. So it is nothing but it signifies this willingness to do. I am just offering willingness to do. I am offering my vehicle. I am offering my hose. And with a view to obtain the assent of the other. From Sophia, I just want to get the assent. That is offer. And what is accepting? Offer? Acceptance. What is acceptance? If the person to whom the proposal is made, I have made the proposal, I have made the offer, signifies his assent thereto. Sophia says that I am ready to purchase the vehicle. That is acceptance. So what is acceptance? Yes, it is the acceptance means the person to whom the proposal is made, the person to whom the offer is made. If I'm just making an offer, you are just making the consent to me. Signifies his assent thereto. You are assenting that I am ready to purchase. That is acceptance. If both have entered into that legal relationship, there should be a unity of minds with respect to same subject matter. That becomes an agreement. So if there is a breach, if you can approach the court, then it is enforceable. That is the contract. So there are different kinds you can just classify in many ways. But the best method of classification, so simple, we could say that contracts can be classified on the basis of creation, on the basis of execution, on the basis of enforceability. So these are the three ways by which a contract can be classified. Yes. So contract can be classified on the basis of creation. How the contract is created on the basis of creation. Then next is the contract can be classified on the basis of execution. How the contract is executed. Then the contract can be classified on the basis of enforceability. How can it be enforced? So these are the three modes of classification. So first, the contract classified on the basis of creation. That can be classified in two. You all know, expressed contract. Another is implied contract. Okay? So on the basis of creation, expressed contract. Another is implied contract. So expressed contract means, suppose I am just entering the contract with Ranzi in writing that I am decided to sell my shop. We have entered the agreement in writing, that is expressed, or by words. I am decided to repair my watch. So by words we have entered into the contract with the shopkeeper. So either by writing or orally you are just entering into an agreement. That is what you call expressed contract. Express contract on the basis of creation. What is implied? Implied can be just by the act of parties or by contact of parties. For example, I'm just traveling and I'm just entering the train and all my luggages are taken by a coolie worker. So there is an implied contract between myself and that coolie worker. It is an implied. It's not expressed, or either it is returned or not orally, but there is an implied contract between us by the act of parties, by contact of the parties. So this is the two classification, maybe classification on the basis of contract by creation, expressed and implied. Another is on the basis of execution. There can be three types: past, executed, and executory. Past means, you could say past. For example, I have offered my shop and Sophia has accepted it. And Sophia has purchased it for an amount. So that was entered before and everything was over before. That is past contract. The contract is over. The next is executed. By the word executed, you would say that it is past. No. ED, executed. No. Executed contract means a present contract. Suppose I am an advocate Fatima. We are entering into a contract. I have decided to sell my one law journal worth 2,000 rupees. And she has accepted it, has given the amount, and I have given my book. So this is a contract. So that is executed contract. At present, we have entered into contract. So executed means it's a present form. Next is executory. I have just paid the amount for delivery of some goods, but it has not been actually reached my home. So the entire contract would be completed only after that particular article has been reached or when it is delivered. So that is going to happen in a future date, but I have paid the amount. So that is executory. That is actually it is going to happen on a future date. Okay, I have paid the amount, but the things has to actually I have not received it. Only when I receive that goods, this contract will be completed. So that is going to happen on a future date, and that is you called executory contract. So based upon the execution, past contract is already over. Another is executed, that means present contract. I have just offered, accepted, given the amount, everything at the very same time. And executory means it's going to happen on a future date. Yes, I've paid the amount, not yet delivered. So the contract will be complete only on a future date. That is future contract, that's executory. And with this, I can just also classify it as unitary or bilateral. I mean, unilateral and bilateral. Unilateral means I paid the amount, but it is going to happen on a future. It is unilateral. Only one thing has happened. Only I have given the amount, but the property or the goods are not been delivered. So unilateral. Bilateral means it's like executed. I've given the amount and I have offered, the other accepted, given the amount, everything completed within a single transaction. Not on a future date, at present. That is bilateral. So you can also actually classify either a unilateral or bilateral. Unilateral, only one person have done it. That other person will be actually doing it on a particular date, on a future date. And in the case of bilateral, everything is in a single transaction. Offering, accepting, purchasing, everything on a single transaction. Another mode, so we have studied by creation, by execution. And third one is enforceability. On the basis of enforceability, we can say valid contract, void agreement, voidable agreement, illegal agreement, unenforceable agreement. So, on the basis of enforceability, 5 modes: valid, void, voidable, illegal, unenforceable. Very simple, okay? So you studied about the creation, express, imply. On the basis of execution, past, executed, executed, or unilateral or bilateral. Third, on the basis of enforceability, 5 categories. Enforceability, 5 categories: valid, void, voidable, illegal, unenforceable. What is a valid contract? When we are entering into contract, we are satisfying the entire elements and the entire provisions for a valid contract. That is a valid contract. When all the conditions are satisfied, all the prerequisites, every essentials, every elements, every ingredients, so as to bring into a contract has been satisfied. then it is a valid contract. What is void? You cannot say void contract because, but there are some instances when at the time of entering into contract it may be valid. Later on it became void, maybe due to impossibility, maybe due to change of law, or maybe due to some other reason. Then it can become a void. For simple example, suppose A has decided to marry a B. Later on B died. So that is not going to happen. It becomes void. So void contract, there is no such word void contract. That means sometimes at the time of entering into contract that may be valid. Later on it just converted. Later on it became void. But the correct form is it's void agreement. Suppose I'm entering into an agreement with a minor. It's void. It's void ab initio, you could say. At the time of entering into contract itself, that is void because it is not enforceable by law. So what is void? It is not any agreement that is not enforceable by law. It's void. What is voidable? Voidable means it is at the option of the parties. Suppose Sophia is entering into an agreement only because of my compulsion, or because of my threat, or because of my fraudulent act. She's entering into an agreement. So later on, she can just accept it. Then it is valid. Or she need not accept it, then it becomes void. So voidable means at the option of the parties, they can either accept or neglect it. Suppose they are entering into an agreement and if they accepted it, then it becomes valid. If they are not accepting it, it becomes void. That's the important part. So voidable means either the party can accept or reject it. It's at the option of the parties. If they are accepting it, then they can say that, you can say that that particular contract is valid. If they are not accepting it, then it is void. So mainly maybe they are entering maybe due to compulsion or force or threat or such other ways you could say. Then it is, you can say that it is not a contract, valid contract. If they are accepting it, it becomes valid. If not accepting, it becomes void. That is voidable. Then next is illegal. For simple example, suppose I am just paying an amount to another person. For what? For killing Ramu. It will be Ramu. Whether it is, if there is a breach, whether I can approach court? No. That is an illegal agreement. So whenever I am just entering into an illegal agreement, all the collateral agreements are void. Because it is illegal. I cannot enter into such sorts of agreements. That is illegal. And another is unenforceable. For simple example, I can say, in the case of arbitration, we cannot just make an oral agreement. The agreement should be in writing. So if the arbitral agreement is not in writing, it is not enforceable. That is unenforceable. Suppose some agreements need to be registered. If that agreements are not registered, then it becomes unenforceable. In some agreements, there is need of stamp. If it is not sufficiently stamped, then also it becomes unenforceable. So these are the different modes on the basis of enforceability. So just wind up, that's creation. You could say express and implied. On the basis of execution, past, executed, executed. And on the basis of enforceability, valid, void, voidable, another is illegal and unenforceable. Very, very, very important. So you got what is void, not enforceable. Valid, you know all the conditions are satisfied. Voidable at the option of the parties. If you are accepting, valid. Not accepting, void. Illegal, as you know, and an enforceability. But in all these matters, Section 10 of the Indian Contract Act is very important. This shows what are the essentials of a contract. What makes an agreement contract based upon some essentials, some ingredients that has to be satisfied. The thing is, There are many ways you can just classify, but I just want to make 10 points with regard to that. 1, there should be proper offer and proper acceptance. 2nd, there should be an intention to create legal relationship. 3rd, free consent. 4, lawful consideration. 5, capacity of the parties. 6, lawful object. 7, not declared void by any law for the time being in force. Another is certainty of meaning. 9th is possibility of performance. The last, legal formalities. If these 10 essentials are there, you can say that's contract. I could say 1 is proper offer and proper acceptance. Very important. Next, it has to create a legal relationship. 3rd, free consent. The capacity of the parties. Lawful consideration. Lawful object. Not declared void by any law. Certainty of meaning. Possibility of performance. And legal formalities. I think the time is up. Actually, we'll discuss these points in the next class.
Thank you.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional